Everyone be seated. We just took a quick recess. It looks like everyone is ready. We are now having the case of Des Moines Civil and Human Rights versus Patrick Knueven. And Mr. Fatino, you may begin.
Counsel, as the court indicated, I'm John Fatino with Whitfield & Eddy here in Des Moines. I guess I'm a Dowling 84 grad here from Des Moines. I'm joined by Patrick and Mary Knueven. They're in the chambers with us today, along with my co-counsel, Nick Grawl. In the limited time I have with you this morning, I want to visit with you about primarily two issues in this case. It relates to the concept of steering. The first is that the district court should have granted the JNOV with respect to the steering allegation, and secondly, that if JNOV was not appropriate, that the district court committed instructional error with respect to the elements of steering. If I can get into these other issues today in terms of time, I will, but otherwise we'll stand on the written brief as presented to the court. In order to analyze these questions today, I want to talk with you a little bit about the procedural history below, some of the limited facts, and then turn to the argument. This case started in 2019, when the Human Rights Commission filed a petition and request for injunctive relief against the Knuevens. Case proceeded to trial in May of 2021. The allegations of the commission had two counts. The first count alleged that the Knuevens were charging higher rent based upon religion and national origin. The second count pertained to this concept of steering, that they were steering people away from their properties based upon religion or national origin. At the jury trial, the jury found Mary guilty on found her not guilty on both counts, found Patrick guilty of only count 2, which was the steering allegation, and imposed the maximum penalty of $50,000. Following post-trial motions, Judge Crane entered the judgment, and this appeal followed. Timely notice of appeal was filed. Ultimately, the appeals were consolidated because there was a lingering attorney fee issue with respect to Mary. There is no cross appeal pending, and I think that will be important when you listen to some of the commission's arguments today.
Talk a little bit about the ordinance at issue here. It uses the phrase prospective buyer. So shall be an illegal discriminatory housing practice for any person or any owner to steer or channel a prospective buyer into or away from an area because of race, sex, orientation, gender, and so forth. Do we look at prospective buyer as to the actual person that is calling, or is it prospective buyer as to what the owner or landlord views the person as? In other words, when they answer the phone, do they think that they're talking to a prospective buyer, and is that how we should define that term?
Justice McDermott, I don't think you actually need to get that far in the analysis, because I think as part of the motion for directed verdict that I was going to address here, there was no evidence of a refusal to lease, rent, offer to sell, or a refusal of a legitimate offer to buy. So I don't think you need to tie into the I guess that would be the subjective manifestations of the landlord or the owner. It's rather that based upon the record you have here in front of you, you don't have a refusal to lease, etc. And if I could take it one step further, Your Honor, I mean, the district court in this case found that a use of a tester was appropriate, and I would admit that the federal case law seems to imply that a use of a tester is a legitimate way to test that means. But I'd also like it to take it a step further, though, Justice McDermott, based upon the language that you've isolated out of the city code. That's why, as part of the motion for directed verdict, we made such a big deal about the fact that there were never any offers to rent. Nobody even came back, as I recall this record, to come back and get an application. And Mr. Abdi, who was one of the fellows who called about whether property was available, neither Mr. Abdi nor the commission ever proved that there was actually rentals available on the day he called. So for
about sub 10 or sub 1 of the code, because that
is the only one that actually uses the term steering, Your Honor.
talking about that there's never a refusal. I see that language in sub 1, but not in sub 10. Sub 10 just talks about steering or channeling the prospective buyer.
Honor, the commission attempted to use this constellation of subsections 1, 4, and 8 of the city ordinance to try and make it appear that whenever you make housing unavailable, that then you have a violation of the city code. But that's why we kept coming back to those facts with respect to the directed verdict motion, that in this record, there was never a refusal to sell, lease, rent, negotiate, or reject a bona fide offer.
Part of the record for me. So if I understand the violations, they only arise out of the 2 phone calls from August of 2017, the tester phone calls. And I know there was a dispute about whether other evidence should have been considered, but that's the violation, or the alleged violations, correct?
Justice McDonald, I don't know where you decide that the exception in this case ate the rule. As I see it, the charged violations were the 2 phone calls that were made in 2017, the woman calling on behalf of a Muslim couple that was a Pakistani couple attempting to be relocated to Des Moines, and the other was from what purports to be a white collar looking for a duplex. Those are the 2 2017 violations. And that's why we made such a big deal of this at trial, is because the commission's been allowed to basically steamroll these people with evidence from 2015, 2016, under the guise that it shows this continuing case of harassment, which first of all we reject, and second of all, it's an absolute violation of the rules of evidence because the city was allowed to put it on before we ever got around to even attempting to put in the evidence of the Knueven's good character. So,
Understand this further then, even on the instruction given, and I know you're challenging the instruction, but even on the instruction given, those 2 phone calls don't prove or establish a violation of element 3, I guess, of the marshalling instruction. There was no discouragement and there was no encouragement of someone else. Okay.
our position, Your Honor, that even based upon the instructions as the court gave, which we believe was error, the way that instruction was crafted, we still maintain that there was no violation because there was no discouragement or encouragement of.
Now, let me ask you kind of a question on this same subject, Mr. Fatino. So one of your arguments is this discourage, encourage is not an accurate rendition of what the ordinance requires. So let's say we agree with you that that was a bad instruction. Do we have to send it back, or can we say that even under a proper instruction that actually incorporated the elements of the ordinance, the case is insufficient as a matter of law?
Mansfield, I would have to say, as I have prepped for this argument, I have breathed new life into that theory that I think you could dismiss alone based upon the directed verdict motion that should have been granted, because there is no refusal in this record, and the directed verdict should have been granted. So I think this court could be well within its authority.
As you read the ordinance, and we're going to hear from the city, but as you read it, steering means into and out of an area, which we're not talking about here. And let me just finish. And then the subsection 1 is there has to be otherwise making it unavailable, which Mr. Knueven didn't do. He was grumpy on the phone. He sounded negative, but he didn't. There was no refusal to deal or anything like that. Is that your? Have I summed it up?
But I want to offer one slight nuance to what you've said, Justice Mansfield, and that is that if we're going to use this analogy or this amalgam of the Federal Housing Act, which is not, the city code is its own creature. City of Des Moines made this. They need to live or die with it. But because there is this suggestion of steering, we have looked to the federal case law, and what does the federal case law require? And then, Justice Mansfield, that's where we come to the conclusion that under steering, there has to be this notion of into or away from an area. And I'll tell you,
Though, right?
but also, though, if you look at this HUD study they've offered, which wasn't in front of the district court, never showed to the district court, but if you have a moment, look at this HUD study, because the HUD study talks in terms of steering as having a geographical component to it. And that's why we kept coming back to the Second and Seventh Circuit cases that talk about the fact that, and the Second Circuit, sets out what the elements of a steering claim are. You have to have a member of a protected class, that they were directed to a different area. And while the housing otherwise remained available. I'd like to shift, if I could, just real quickly. I think we've talked a lot about the steering issue. I want to get into the 2015, 2016 evidence. And again, that evidence, even though we maintain it was improperly admitted, though, still demonstrates to the court that there was no refusal to deal. And just to refresh the court, we had the Muslim woman who appeared with the hijab. That was Ms. Ingram. But on cross-examination, she admitted that Patrick answered her questions with respect to utilities, lawn care, snow removal, maintenance, the surrounding neighborhood, and local schools. He didn't refuse to deal with her. He was agitated, as he said in his own testimony, or irritated, I think he testified to, at trial, that he wanted to make sure her husband was there because it was on the other side of town and he didn't want to have to drive back and forth. We had the Chris Foltz visit. He was a white fellow who described his visit as uneventful. Jody Moshik was the white woman who came to rent. He notified her about the maintenance obligations of the property. And the other was this Deek Abdi fellow who admittedly was an immigrant who spoke with a deep accent. But Mr. Abdi testified at trial that he thought he was dealing with a female named Pat. And as I alluded to earlier, the commission, neither Mr. Abdi nor the commission ever came back and proved that these properties were in fact available once Mr. Knueven told Abdi that these properties were not available. So there's no evidence in this record to support it. I also would like to visit with you just briefly with the time I have that the 2015-2016 evidence should have been excluded based upon the city ordinance alone. And as we've cited for you, the 2015-2016 investigation was stale by some 556 days before they started to make the 2 phone calls in 2017, because City Code Section 62.2b requires that a complaint be filed within 300 days of the discriminatory event.
For abuse of discretion, is it reversible error to let that evidence in to show his motive or intent?
He was, Your Honor, and plus, because we've set out really 2 factors for you in the brief. First of all, there's just this notion that if the evidence were admissible, you still have to do the 403 analysis, and that is it just so overwhelmingly prejudicial that you have to exclude it. Now, the commission and the court looked to this Morgan case, and we've cited a number of reasons for you in the brief that Morgan is inapplicable, because Morgan dealt with a specific characteristic, a specific employer over a number of years. And the problem with all of the calls that the commission has introduced here is they're multifaceted. Was that call about gender? Was that call about having children? Was that call about your source of income? Was that call about what your religious affiliation is? It's just all over the board, and that's why it's prejudicial. With the remaining time I'd have, I want to share with you what I think is ultimately the most prejudicial thing in this case, beyond the fact we didn't get the directed verdict, beyond the jury instructions, is this fact that after the commission has been allowed to parade around all of these horribles since 2015, we moved to introduce the Iowa Civil Rights ruling that was contemporaneous, that showed he had received a favorable...
For what type of a discrimination? Wasn't it disability-based, and from what year?
16, and it was disability-based.
Rallying against any evidence from the other side from that time frame. So it's older, by your own admission, and it's unrelated to housing discrimination as far as for the reasons that this case was filed.
The commission opened the door, Your Honor. I mean, shouldn't he be allowed to at least offer some evidence? And that's why I think procedurally the commission again put the cart before the cart before the horse here, because Patrick did not put on evidence of his good character that allowed the city to put on this evidence from 2015, 2016. They started right out of the gate. Go back and look at the transcript.
Is that the prior bad acts are not character evidence, and what you were trying to introduce was character evidence, right?
It's part and parcel, Justice Mansfield, of the same thing. If the commission has been allowed to spend all trial about what a negative white guy he is, he should be allowed to introduce evidence of the fact that he had an experience with the tenant that related to a form of discrimination, and that charged He prevailed on that charge. So as a result, the jury should have been allowed to consider that. And it's contemporaneous, as I recall, to these other ones. So
Case should be dismissed, that you are entitled to a directed verdict or JNOV, then he becomes a prevailing party and he's entitled to his fees. And that requires a remand for that determination, right? You don't have a fee affidavit as part of the appeal.
it would, and I think that's issue number 6 in the brief, is that if the positions get flipped, I see my time's expired. May I have a moment to conclude? Yes, Your Honor, that if the case gets flipped and sent back down, I believe that we would be entitled to a prevailing fee claim. So, thank you very much.
Mr. DeSmet?
Thank you, Your Honor. May it please the court, Luke DeSmet representing the Des Moines Civil and Human Rights Commission. I grew up in Mitchell, South Dakota, but because of a last-minute move, I graduated from Oak Creek High School in Oak Creek, Wisconsin in 2021. But we're here today because Patrick Knueven engaged in discriminatory steering in 2017. He did this by not volunteering information to the protected tester, by offering the unit at a higher rental rate to the protected tester, and by just generally failing to be courteous and someone that a person would want to deal with when talking to the protected tester.
Can I ask you, now we talk about testers in this situation. We're talking about people who are just pretending to want to rent. Isn't that true? And so they make phone calls and they talk to the defendant, but nobody was actually trying to rent from him, correct? That's involved in this case. All right, and now I read some of those federal cases to say that you could have some evidence from testers to support a discriminatory motive, but I'm not sure I found one where it was based entirely on testers and no prospective buyer was actually involved. And did I overlook something?
The federal cases, I don't remember reading a federal case that says you have to have someone actually interested in the case. Multiple of the cases are brought by fair housing agencies who gather their evidence entirely by testing. And so offhand, no, I can't point you to a case that I'm certain only has tester evidence. But I also don't recall any case that says you have to have something more than tester evidence.
About these municipal code provisions here, they speak of a prospective buyer, for example. And that, in my simple way of reading it, suggests that somebody who actually wants to buy, and these testers clearly wouldn't qualify, and it seems like to me.
For subsection 10, but not for subsection 1. Federal case law is very clear. I mean, when we look at the Federal Civil Rights Act or the Iowa Civil Rights Act, there's no mention of steering in either of those statutes. The case law indicates that steering is a form of making housing unavailable. That's a provision of the Des Moines Civil Rights, or the Des Moines Municipal Code as well in subsection 1, that it's unlawful to make housing unavailable. And so there's no reason that we should say, because the Des Moines Municipal Code makes it clearer to potential housing providers that steering is unlawful, that we should consider steering to be less broad and have more requirements under the municipal code than it does under federal or state law.
Ordinance still requires that the property be made unavailable. That isn't what happened here. All we have here is, kind of a negativity on the phone call, right?
Case law discusses that any action to discourage one group while encouraging another group is a form of making the housing unavailable that constitutes steering. And I mean, there are multiple cases that talk about that, misrepresentations, any effort to discourage.
Presentations made during this phone call?
I don't believe that Mr. Knueven made misrepresentations during the 2017 phone calls.
We're going to say unavailable and you had a list.
In one case, refusing to call a superintendent and not volunteering information.
Was there a refusal to call Was there information that the caller asked for that he didn't provide?
In this case, Mr. Knueven did refuse to volunteer information to the protected tester. And, and that's really apparent when you listen to the 2017 phone calls. When he's talking to the control tester, it is a friendly, jovial conversation. He is a business person who wants to make a sale. And when he's talking to the protected tester, who indicates up front, I'm calling on behalf of protected individuals, that attitude is completely different. He doesn't, every answer is monosyllable. No, no, and he's not volunteering information. So there is a difference here that when the control tester calls, he volunteers all kinds of information about, I haven't shown the unit since I last talked to you. I have people that are willing to make an offer, but that doesn't happen at all when he's talking to the protected tester.
But it still requires refuse to show, refuse to negotiate, refuse to sublease or assign or otherwise make available, or deny a dwelling. None of those things happened here, right?
Encouraging one group while encouraging another group under the case law is a form of making the housing unavailable.
Like Justice May, I'm just reading the ordinance, and that doesn't seem that broad. I mean, and I guess I'd be a little nervous if it was that broad, because the potential for exposure and liability would be very wide.
Case for the proposition that the failure to affirmatively offer information, even when the questions weren't asked. I mean, I listened to the call. The caller didn't ask a lot of questions either. So there are no misrepresentations. It's just rudeness. I don't think anyone would dispute that the call was, his tone was different and it was rude. But if there's no misrepresentations and there's no denial of information, what's the best case that stands for the proposition that that means making housing unavailable?
The Fair Housing Justice Center versus Broadway Crescent case, in which the defendant in that case refuses to call the superintendent or calls the superintendent based on the different character of who she's talking to. That case also discusses that the jury can consider the tone in which that individual is speaking to the testers. Which is similar to what we have here.
Relevant, but if that's all you have, I mean, it just strikes me that, if I was the supervisor for these testers, I'd say, hey, you need to go back and make another phone call and get something more than what you got.
Rude by itself probably would not be enough. That we need some affirmative act by Mr. Knueven to engage, to show that he's engaging in housing discrimination. We have two of those here. One is the refusal to volunteer information to the protected tester, and the other is the difference in rental rates that he offered the control and protected tester. And so we have those affirmative acts coupled with the difference in attitude that he has and the rudeness, and based on that, the jury was able to find that he did engage in discriminatory action by steering.
Let me ask you another question. At this point in time, the ordinance didn't prohibit discrimination based on source of income. Isn't that right? That was added by the city in 2019, something like that, am I right?
I don't recall when that was added. I know the legislature since made that, I think the legislature's made that illegal since then.
And I didn't even know, you're more familiar with this area, but I mean, would it be possible, I'm just raising an issue and maybe this didn't come up at the trial, but would it be possible for the defendant to say, well, I wasn't concerned about these tenants because of their race or religion. I was concerned because they were being, according to this story from the tester, they were being referred by a refugee agency, and that might not be a stable source of payment for my rental. Would that be lawful if that was the basis on which the landlord acted?
Question to whether or not that's lawful, but if that was an argument that Mr. Knueven wanted to make or have the jury consider, he had the opportunity to make those arguments and have the jury consider that, and so I think we're past the point of him making that argument in this case.
Sorry, you go ahead.
I want to go back to the two things you identified from the calls is that he failed to volunteer information and then he offered different rates. What do we make of the fact that the jury found him not liable under count one related to different rates?
they found that the rental rate alone wasn't sufficient to show discrimination, doesn't mean that they couldn't consider that as evidence of the steering claim. And so I think it's still appropriate for the court to consider that as something that the
Anything about that phone call, if we didn't have the lack of voluntary information, does that change that? Or are those effectively the same claims? Or I get, that's not a very good question. And my question really is, if that's the only thing that, that you're relying on from the phone call was the different rates, does the fact that the jury found that he did not actually charge different rates affect the steering claim?
might be an issue in that scenario, but that's not all we're relying on.
Okay.
Counsel, on section 10, the steering section, it says steer or channel a prospective buyer into or away from an area. How do you respond to the argument that the steering wasn't relating to an area, like an area of town, a particular neighborhood, but particular dwelling units that this landlord owned?
Two things. First of all, in this case, we made clear to the district court that we weren't intending to proceed under subsection 10, but under subsection 1 about making housing unavailable, just like steering is a form of making housing available under federal law and under the Iowa Civil Rights Act. But second, I think that steering is inherent in the action of making the housing unavailable. Anytime a landlord discourages one group while encouraging another, they are inherently steering the group they're discouraging to somewhere else. They may not do the geographical direction that Mr. Knueven advocates for by saying, well, you really ought to go over there. But anytime they're making clear to a person, you don't belong here, they're implicitly telling them, go somewhere else. And so I think that that's not something that's required under steering law.
Here to volunteer information that wasn't requested is a clear signal that somebody's making housing unavailable?
I think that on the facts of this case, it is, Your Honor.
Calls and just says, do you have a rental unit available? And he said, yes. And the caller said, thank you. And that's the end of the call. And he didn't offer up the rate, and he didn't tell the caller where, and he didn't say what kind of house it was, and he didn't tell the bathrooms. That's a discouragement of housing availability?
By itself, no, it's not. But we have more than that in this case. I think something more similar to this case would be if we added to your scenario to say that the protected tester calls and asks with an audible accent and says, do you have housing available? They say yes, and the phone call ends. But then you have a control tester who doesn't have an audible accent, calls and asks, do you have housing available? And the housing provider says, yes, let me tell you about it. They're volunteering information to the control tester and not volunteering information to the protected tester. So I think we would need more than what you laid out in your scenario to find discrimination occurred, but we have that more in this case.
Jury instructions number 13 in particular, that was actually adopted by the court, so would be the instruction that we are looking at. Subparagraph 3, the defendant engaged in steering by discouraging blah blah and encouraging blah blah. So the instruction itself hones in on those two broader terms. If the court is along the lines of what Justice Waterman asked earlier, of opposing counsel, if the court were to say, maybe that should be elaborated more, maybe that should be fleshed out, maybe we should say exactly how, like taking steps or what? If that were the case, and this instruction is a problem, what happens on remand? Is it retrial or is it dismissal, and why?
I think that the instruction itself is sufficient to indicate to the jury that an action is required. We've talked about the fact that
The court is persuaded that the one that was given was too broad. If the jury deliberated on this broader instruction, just using those words, encourage and discourage are the law of the case, that's what the instruction was. If they relied on that in coming to their conclusion, and we think that the instruction should have been a little tighter, I'm asking you, just assume that. I know you don't want to admit that, but assume that. I'm just trying to flesh it out. What would happen on remand? Would it be remanded for a new trial because the jury looked at encouraging and discouraging words from that instruction? Or is there enough evidence out there to say, even with just those two words, encouraging and discouraging, the case should be dismissed? Trial or remand for dismissal?
Retrial, because there is enough evidence in this case to show that Mr. Knueven treated the control and protected testers differently.
Encourage and discourage?
I think that he did encourage and discourage by his rudeness, but he took the affirmative acts regarding volunteering information in the different rental rates as well.
Clarify, I mean, there can't be kind of a free-floating violation of the law. So what is the statute or ordinance specifically that you're arguing he violated in this case?
Civil Rights Act and the Des Moines Municipal Code language under subsection 1 in terms of making housing unavailable by steering the protected tester away from his housing.
101 A sub 1, that's the provision you're relying on.
Corresponding provision under the Iowa Civil Rights Act. I see my time is up. Thank you, Your Honors.
I have another question. Sorry. Why not sub 2? Why did you not argue sub 2? Just out of curiosity, that kind of directly or indirectly indicate that a rental or dwelling by persons of any particular religion and national origin are unwelcome.
I'm afraid I don't recall the answer. I'm not sure what the answer to that question is, Your Honor. Thank you.
One follow-up to that, Chief, sorry. So I'm reading section A1 now, and tell me if you agree with this. It's fairly clear that none of these provisions are even remotely close to being violated, except for the language otherwise make unavailable. Would you agree with that?
I agree that making otherwise unavailable was violated in this, is what we're arguing was violated in this case.
Language in this particular provision that's even at issue in this case, because everything else is refuse to sell, refuse to show, refuse to negotiate. None of those things even got. Those two calls did not get to that point.
Is what we're relying on, yes. Thank you.
Chairs. Yeah, sorry for that. Mr. Fatino.
Thank you. If I could follow up, maybe let's talk about some of the questions that I did hear addressed to opposing counsel, and then I'll circle back into my final comments. And I was going to point out to the court that, you know, the jury found the Knuevens not guilty of this differential rate issue, and there was credible testimony at trial that the jury was free to believe to reach that conclusion. So to squarely answer Justice Oxley's question, I believe that the verdict has to be looked at in the light most favorable to that result. So the fact that they were found not guilty of that charge literally falls away and really is of no consequence for the court. To follow up on Chief Justice Christensen's question, I believe that the case should be dismissed because of the fact that there was this, and I'll chunk it all together and say no refusal to deal. Nobody came back to get an application. Nobody pushed harder for rent. And I have thought of all kinds of examples that none of you have asked me that could have made for a charge in this case. But that's just not the record you have in front of you. You have this weak attempt to call him. Apparently it's, you know, that if he didn't respond with the crisp and celeric tone the city expected, that, you know, this is some charge of discrimination. But I answer that question in the context of Chief Justice Christensen's question that, first of all, I think the case ought to be dismissed just directly now. But if a majority of the court were to decide that the instruction given was too broad, I think the court needs to seriously focus in on the instructional error that should have been the proposed instruction that we submitted, and that's on page 75 of the appendix. Because we take the position that the proposed instruction that we were proposing is in fidelity to the circuit cases that have decided this issue under the Fair Housing Act. So if the court were to decide that a remand for retrial is appropriate, I'm not suggesting that this is just a fallback position, but I'd strongly encourage the court to look at page 75 of the appendix because that contains our proposed instruction that if we're going to buy into this analogy of the Fair Housing Act being breathed into the Iowa Civil Rights Act and the City of Des Moines ordinance, that if at least we're going to use that analogy, we need to do it correctly.
And if we were going to do that, that would, if we were going to adopt your jury instruction on 75, that forces a decision of the prospective buyer, because that is throughout that instruction is what drives it, right?
And as I'm standing here today, I guess you could also tweak it as to a lease or tenant. I don't have that in front of me at the moment, that exact language. But I mean, you could certainly remand it. But I think, again, the point is that to engage in steering under the federal cases, as we've cited to you, there has to be this notion that you are directing people away. Don't take my word for it. Look at this HUD study he submitted in the resistance brief. Even HUD looks at steering as the geographical, race-based component. You know, white people get sent to one suburb, the African-American folks get sent to a part of Chicago. That's what those cases talk about. I'm sorry, Justice Christensen, did you have a question? Okay, all right. So it's really our position that there is no case law from any federal jurisdiction or any state jurisdiction that we could find that supports the notion that a defendant's tone of voice, the details by which they respond to a question, facial gestures, the type of radio station you're listening to when showing a property to a tenant amounts to steering as a matter of law. This record...
That pretty clearly, though. The tone of voice portion of your proposed instruction was always included in your steering, and I believe she was not persuaded by that argument. And I could foresee some examples where tone of voice, to have that in an instruction, that tone of voice, et cetera, are not steering under the law. Oh, I could imagine some pretty snarky people talking, and where maybe it does definitely lean towards part of the evidence, but to say that's not steering, it could contribute to the steering, wouldn't you say?
Decided to eject that last part of the proposed instruction on page 75, you still have this notion that the properties, that there was a bona fide offer to lease, to rent, and it was rejected. And I think...
For your proposed instruction on 75, and it includes that last paragraph, unless you want to just bail on that one part of it.
Make a deal. I think you ought to dismiss, but if you're going to remand it... Oh.
I'm trying to conceptualize this. So you objected to the instruction Judge Crane gave, correct? So it's not law of the case because you objected to it. So then, but we do, if it's incorrect, then we go back and we have to look at, is there sufficient evidence under a proper, would there be sufficient evidence under a proper instruction? And if so, it's a retrial, and if not, then it would be dismissal. Is that the analytical approach?
May I have a moment to conclude? And then just to squarely answer, though, Justice Mansfield's question, I think that the proposed rule or the proposed instruction on page 75 would be the appropriate one, but certainly this court, though, as part of the remand, if you think 75 is too broad with respect to the tone of voice or whatever else you determine is inappropriate, we do have in the record what we thought the proffered instruction should have been on the issue of steering.
Back to that, you did agree, I thought there was something in my notes here, you did agree at trial that the governing standard for housing discrimination required the commission to prove the discrimination was a motivating factor. You did agree to that, correct?
And I want to clarify that, Your Honor. Well, go ahead. Okay, no.
I had my memory, my recollection.
Motivating factor, but Mr. Grawl, this is on page 16 of that June 16th hearing, aptly pointed out that, yes, there is a such thing as a motivating factor, but when you have the way the commission put in the evidence from 2016, there's no requirement here that the commission prove that we knowingly, willingly, negligently, recklessly did these things, so that to suggest that this 2015-16 evidence was proper because motive was an issue, I believe that my comments at trial were more related to this McDonnell-Douglas shifting type burden, that if the commission proves X, the Knuevens get the chance to show a legitimate non-discriminatory reason, and then it shifts back. That's what I believe my comments were at the time, Your Honor.
Can we go back to efficiency analysis real quick on the retrial issue? So I guess I'm having trouble with the thought that under the plaintiff's instruction, or the city's instruction, which is most favorable to them, if we conclude that the evidence is insufficient on the instruction they requested, shouldn't that be the end of the case, even though you thought it was an inaccurate statement of the law. I mean, they put forward their best case, their best theory. If we conclude they failed to prove it up, I'm not sure why they would get a retrial on a different theory that they reject when they've already had their shot at this.
Correct, Your Honor. My point is that the directed verdict should have been granted because there was not a refusal to lease, sell, et cetera, et cetera. I'm just suggesting prophylactically, if I don't get a majority of the votes and you decide a remand's appropriate, I think there was instructional error and you need to address that on remand. So, all right. Thank you very much, Your Honors.
Of Des Moines Civil and Human Rights Commission versus Knueven is hereby submitted, and court is adjourned for the morning. Thank you for joining us, students and others.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.